Hey guys, I'm here with Leor from Albert McKenzie, who's our preferred law firm. We're going to be talking about the N6220 order from Mr. Newsom. Good man. And a few other things, what you can do to protect your business, protect your employees, making sure that you and your team are staying safe and protecting yourself from future litigation. So let's get to it. Whiteboard Podcast, Episode 7. I'm back with our favorite guest, Leor.
Naturally.
We've only had 7, dude. Don't flatter yourself. We're going to get more. Well, thank you for making the time to do this. Thank you for risking your life going out with a mask. However, you have no signs, no symptoms of any COVID.
That's right, and I've actually had negative antibody testing.
Hey, let's go.
Wish I had it, but
wait, that's not good. What you want is the positive one. Saying
exactly.
I heard that that's not very accurate, though. Like 70% of the time, it's accurate, and then 30% you're like, maybe I had it.
Yeah.
Yeah. Okay. Well, makes you feel good.
Yeah. Check CBS hourly, and they'll give you a new opinion.
For sure. That's how it is. So while it has not impacted you personally, professionally, it's made you lose some sleep.
Absolutely.
Okay.
These are unprecedented times is the understatement of the century. But in typical California fashion, the way that the governor has chosen to deal with this crisis is, I would say, unprecedented and is really going to put a large burden on employers who are trying to reopen amidst all this craziness.
Sure. Yeah, he just jammed it down employers' throats and insurance companies' throats, both of them. It was a horrible place to put the insurance. I don't think I mentioned this to Alex on our last podcast, but it's if you were going to place COVID anywhere on the insurance scale, it should have been done on the business income and interruption. Like, that's the only place to put this. The fact they put this on work comp is irresponsible at best.
It makes no sense.
Yeah.
It really doesn't. And we've had news trickling down from Sacramento for quite a while now. We've been watching these bills that have been passed along, talking about what was going to be protection for first line workers. So it was going to be a presumption of ensuring that if you're a nurse, if you're EMT, if you're a doctor, if you're providing first line defense, potentially even applying to workers that are a part of the critical infrastructure. And that was what we were expecting, is some form of formal law having been debated by the legislature. And instead, Gavin Newsom turned around on May 6th and surprised everybody by issuing N6220, which is an executive order providing a rebuttable presumption of workers' compensation liability on carriers and employers when an employee is working at the workplace. And that went into effect retroactively March 19th, 2020. So the day that the stay-at-home order went into effect is how long it goes back towards, and it will go forward for 60 days from the order, or it expires on July 5th, 2020, presumably when the legislature will finally have provided formal guidance and enacted some sort of legislation.
Sure. It seems like they shot first and decided not to aim kind of situation here. I don't understand. So part of the problem is the workplace portion that we were initially talking about. When they talk about, contracting COVID and putting that all the way back to March 19th, that's if you contracted in the workplace, right? Which is relatively vague. However, for people who are on the front lines, like nurses, doctors, that all makes sense. Most likely where you're going to contract COVID is going to be on the front lines.
Precisely.
The problem, though, is the workplace, right?
Yes. This order is it's maybe 5 pages, and the level of detail it provides leaves wide gaping holes that we are now left to try to unpack and do with as we can. So under these restrictions, of course, as a defense attorney who represents insurance company and tries to act in the best interests of employers, we are going to interpret this order conservatively and in such a way that represents our clients, while also ensuring that employees are treated ethically, fairly, and if entitled to benefits, that they receive them. So, for example, when we're talking about working in the workplace, this order doesn't say anything about people who are delivery drivers or people who are providing house calls, an electrician, a plumber, HVAC. We don't know whether or not they would be covered or not. You could spin this any number of ways. You could say that maybe the legislature, maybe the governor intended it only to apply to workplaces specifically because an employer literally has the ability to control their own environment. So that would be ensuring that employees are staying 6 feet apart, ensuring they're wearing protective gear, ensuring that there are screens enacted between them and the public, etc. And perhaps the governor didn't intend to cover Amazon delivery drivers because the employer can't control that outside environment. Or maybe they did.
Yeah.
We just don't know one way or another.
I mean, I would probably take a guess on which way Newsom decided to make that one go. You know, if you're going to lay a bet, for sure, that's what his intention was.
Maybe we'll get a tweet and he'll update us.
Yeah,
but
hopefully. That would be nice. You talked about controlling the environment. So a lot of our clients are coming back to work. So if you were deemed non-essential, most of our clients, I would say 98% of them are going to be back rocking and rolling. 2% of them, like, they might never recover. And that's just a sad truth of this unprecedented thing that happened to us. And while it sucks, the other 98% is like what we have to worry about. What are the best practices moving forward? And we've sent out a ton of articles on what you should be doing in regards to preparing your employees to come back to work, how to check temperatures, what PPE they should be wearing, et cetera. Can you kind of elaborate on that now that we know that this is going to be covered by workers' compensation? Like, the stakes have just been raised for the employer even more.
Hugely. John, you just went through a short list of all the best practices, and the priority is for these employers, these businesses, to reopen to the best of their ability. And irrespective of what the legislature may do, get back to work. These are trying times, so you have to do what you have to do essentially in these times. But the things to be cognizant of and what N6220 means for employers is the governor has created a rebuttable presumption of compensability. In a normal workers' compensation case, an injured worker gets injured or claims injury, brings it to the insurance company. The insurance company has a period of time, typically 90 days, to investigate and then make a decision on compensability. Either we accept or deny. The burden of proof is then on the injured worker to prove that they actually were injured in the course and scope of their employment. However, the governor has now flipped that on its head. What the governor has done is he has provided a presumption of compensability for employees, assuming they meet a list of criteria. And once that criteria is met, the burden shifts to the employer to disprove their claim.
Impossible. Not impossible. Sorry for using that word, but it's damn near impossible. Like, you'd have to do tracking of where all these employees have been. Like, it's very, very, very difficult. And especially if one of those employees infects all the other ones, like, all right, well, how many work comp claims is that?
You're not wrong. I mean, if we were somewhere like Singapore or Japan where they do have very detailed contract tracing, they have trackers on their phones and their apps, that would make it easier strictly regarding keeping track of whether or not an employee contracted it at work. I'm not talking about civil liberties here. That's a whole different. Yeah. That's outside my wheelhouse. But you're correct. And this order only made it more difficult. So why don't we go through quickly what the criteria is. So the first is, like I already mentioned, it does apply retroactively. So it went into effect on May 6, 2020. It applies retroactively all the way to March 19th, 2020, and will only be in effect until July 5th, 2020. That means if you contract COVID-19 within 14 days of working at the workplace, and it was at the direction of the employer, then within 14 days, there's now a rebuttable presumption. You also have to either test positively, or you have to be diagnosed by a physician who is licensed in the state of California, and also test positive within 30 days. Because sometimes you'll go to maybe perhaps an urgent care, or you'll go to a hospital, maybe they don't have enough tests. That's not as much of an issue now as it was before. But if that happens, they have 30 days to then test positively, as opposed to just having a suspected diagnosis. As long as all of those criteria are met, the burden shifts to the employer. And like I said, instead of having the 90-day investigation period that we normally do, the insurance company has 30 days to issue a compensability decision. And on top of it, with these rebuttable presumptions, if there's information that is discovered after this 30 days that a judge up on high decides should have or could have been revealed in the prior 30 days, then you can no longer retroactively deny the policy.
Wow.
So those 30 days are crunch time. This is really, this is no joke. You know, this is not the typical period where paperwork comes in the door, it kind of sits on the desk for a few days, hopefully it makes it to your broker, and then it gets passed up to the insurance company 2-3 weeks later. This thing really needs to be provided to your insurance company as soon as possible, because they need to send out an investigator, preferably, because I'm going to want to see what your workplace is like, what your procedures are, what kind of safety gear that you're providing. Like we said, are all the workstations every 6 feet? What kind of density is there?
How far does that go? I mean, it's obviously we don't have a ton of territory to look back on, but how far will that go? I mean, let's say you did everything by the book, right? That presumption of compensability, I feel like, is the issue, right? Even if everybody's got N95 masks on, you're 6 feet apart, you have, plastic in between you guys, like, still, right? Does that even do anything?
Absolutely. I would say this is how I'm thinking about it. And all this is unfolding. There hasn't been a N6220 court case yet.
Sure.
So, we're not going to be dealing with this in the courts for quite some time. But what I would say, if I'm litigating my first COVID case within a specific workplace, if I look around and I see that distancing is properly implemented, employees aren't sharing lunch in close quarters, N95 masks are being provided, there's hand sanitizers on the walls and everybody's desks, temperatures are being taken, all these steps are implemented, there's good ventilation, and there hasn't been a single COVID-19 contraction, I would argue that should be sufficient for a insurance company to argue that the presumption has now been rebutted based on all these facts, and that potentially that would be a basis to deny it. You would also, of course, want to look at the nature of the business. That's also going to be a big one. If you have a person working at a grocery store, that's going to be a tough one to defend.
Sure.
You have the public running in through everything, but if you have a place of employment that has 30 people working in a warehouse and the public never enters into the picture, and the only people walking in and out are controlled and all employees who are following these procedures and steps, I would argue that's a pretty good case. Now, fast forward 3 months from now, if there's already been 2 COVID-19 positive tests within the workplace and now multiple employees are starting to catch it, we know this is a pretty contagious disease. So even if all the safety steps are still implemented, under those facts, could I say that I would feel as comfortable outright denying simply because the employers followed the rules? I don't know about that.
Is there any benefit for an employer to purchase tests, either the antibody tests or the COVID tests? Is there benefit in doing that, or is that opening themselves to a liability saying, we're doing the testing, but someone slipped through, let's say you do it every 2 weeks, something like that?
I would say that's liability management, because on the one side, assuming your employees continue to test negative, then fantastic, because now I actually have evidence to prove that there is no infection within the workplace. But people are going to go home, people are going to go to the marketplace, businesses are starting to open. People might go to restaurants. We don't know if they're going to go to bars or not. They're probably not going to baseball games anytime soon.
Sure.
NBA. But the point is, doing these tests certainly can open you up to liability. But on the flip side, let's say you test every employee once a week.
Yep.
And you catch 1 or 2 individuals that test positive. Fantastic. You send them home. From that point forward, at least according to the medical literature, assuming nobody else has it, then you'd have, if there's 14 days of no infection, then maybe that kind of restarts your clock.
Sure.
But this is all evolving. So,
yeah.
Something that we may start doing is literally consulting with infectious disease experts, bringing them into the workplace. This is really uncharted territory. And
we've been looking into that too.
Yeah.
Yeah. There's a few out there doing it. One of our partners that we work with, Got Safety, is looking at contracting one. So I know that that's on the horizon. I am curious though. This is because it's so unprecedented. There's other respiratory. I know we have a claim right now with one of our clients up in Bakersfield. I forget exactly what it is. There's some slang term for this cough that they get because of all the dust up there. Mm-hmm. And that was an accepted claim, which is a respiratory issue. But there's are there any other cases where you see any of these work comp cases from respiratory issues, or is this the first thing you've seen?
Respiratory issues are definitely rare.
Yeah.
One of the most troubling ones that I saw was silicosis. I'm sure I'm mispronouncing it, but it's essentially stone workers and people who are exposed to constant dust from cutting marble, slab, quartz. If they don't have proper ventilation, their lungs literally start to harden and require a lung transplant. So that's an example of sure, there's no presumption in favor of that individual, but you show me somebody who's been working with stone for 25 years.
Good luck.
It's going to be hard proving it was anything else.
Sure.
I've also had, for example, I had a few cases where individuals who were working with industrial materials, they were alleging some throat irritation,
I've seen a couple
some
of those,
breathing problems, and some asthma.
Yeah.
In those cases, you pull the MSGS sheets and you see what they say. And depending on what materials they're working with, many of them will end up having mild irritation as one of their symptoms. But what I'm really looking for is evidence of cancers or development of serious injuries.
The big ticket items.
Exactly. So there is precedent for dealing with respiratory issues. But another analogous line of cases that we're really looking at right now is also the infectious disease cases. For example, you have somebody who develops tuberculosis. My sister, for example, she's a nurse, and she was exposed to tuberculosis on the job. She tested. It's dormant, I believe, is how it's characterized in her case, and there's been nothing from it. But in those scenarios, that's kind of where we're trying to draw from.
Sure.
Another place that is a good way to think about this is because of this presumption, I believe that some of the case law is actually going to follow what is already going on with a lot of peace officers and firefighters and government workers, because in these specific professions, there are a lot of presumptions that they get. Yep. For example, if you are a police officer, correctional facility officer, even a campus security guard for the UC system, and you've been working for 5 years full time, if you have a back injury of any kind, it is automatically presumed impensable merely because you wear that Sam Brown utility belt.
Wow.
So that type of presumption, however, has now been extended by Gavin Newsom to every employee. We're essentially saying if you go to the workplace, your lungs are wearing a Sam Brown belt.
Sure. I know firefighters have that same thing. Presumption if they have any respiratory issues.
Respiratory, they have cancer presumption.
Yeah.
And it makes sense depending on the profession.
That makes sense.
This was unexpected.
Sure. So you said there's the 5-page N992?
6220. N6220.
6220. You said there's a lot of unknowns in that. Are there any knowns that are benefiting the employer, such as like utilizing PTO or, maintaining that folks get, flexible work schedules and anything like that?
Great question, and you're right on the money because Gavin at least got one thing right, which was right golf club.
Yeah.
What he did was, assuming an injured worker develops COVID, they would be entitled to temporary disability benefits just like they would in a regular workers' compensation case. However, the requirement is that they first have to exhaust any sick pay that they have, any sick-related benefits that they have. So for most people, that's going to be just their general sick time, whether it's 4 hours a month, 8 hours a month, etc. There are certain people that actually have employment contracts. I know that some government workers have contracts where after certain amounts of after their full sick pay is expired, then some of them have almost salary continuation agreements where they get a certain number of hours at 80% salary, and then it can go lower. If it would go lower below what would have been their temporary disability rate, then I would imagine at that point probably the insurance company would have to make up the difference. But at the very least, you do want to immediately notify your insurance company the second you get a COVID case of what sick time that the employee has.
Sure.
And
is that specifically sick time? Because I know there's that. I'm sorry for asking a question that might be out of that, but like a lot of folks just have general PTO. 5 days of sick time are just baked into that. So is it all PTO? Is it specifically sick time? If they don't have that outlined anywhere, how's that work?
So Newsom forgot to include PTO.
Nice.
But no, I would certainly argue, and in my cases, I will be arguing that unless there is clearly delineated vacation versus sick time, if there's this flex time, which many employees are provided, I would argue that should be exhausted.
Absolutely. That would make sense for me. We'll see how that turns out. Yeah, man, that's difficult.
Yeah.
How are you holding up through all this?
Holding up well.
Yeah.
Holding up well. Luckily, attorneys we can work from home. We're sitting behind a desk anyway, so move the desk around. The work stays the same. It's been, it's been a little challenging working from home. The distractions of a delightful, annoying 10-month-old son.
Yeah.
Sitting in my garage, sweating in Woodland Hills, 100-degree weather in the middle of May.
Yeah, exactly.
But it's an interesting time. It's an interesting time to be in the workforce, and dealing with these constantly evolving challenges is it's scary. But at the very least, I'm almost honored to be able to help this process of reopening while everyone's struggling. Man.
This can be done so poorly. Obviously we had no clue what was going on, and everybody can play armchair quarterback and say, hey, I would have done this, we could have done this, all retrospectively. I think if we don't handle this appropriately, we have to shut down again. Like, that's borderline unrecoverable damage for a lot of these small businesses. And so it's important that everybody does the right things to start, right? That means if you have the capability to do that, if you are a state fund's giving $10,000 to each one of their policyholders for like PPE. You just send them in their seats and they get 10 grand to it, which is awesome that carrier's doing that. So I would say all the stuff that you're recommending, the N95 mask, the temperature checks, keeping 6 feet apart, like all those things, make sure you're doing those. Because again, if this goes sideways, like the whole state's in a bad spot. I think the country will be fine. I'm mostly worried about California. And it is because of who's running this show. Like, it seems nonsense. Like, what happened in LA, Garcia taking it back to August, which I think he's peeled back some of that because he got such a massive pushback. But if that didn't happen, like just shutting down until August, like most businesses cannot sustain. Like the PPP that most folks got, like
it can only do so much.
You're putting a Band-Aid over a wound that is growing, and that's a problem.
Well, John, can I ask on the insurance side, do you guys have any indication yet from the DIR or the insurance commissioner on who's going to be footing the bill?
In what capacity?
For these COVID-19 cases?
Do you mean like in regards to business interruption or work comp? What do you mean?
Premiums.
Oh, premiums. Oh, gotcha. In regards to the WCRB. So there's, which is ironic, I've seen some law firms, and I want to talk first about the business interruption. It looks like people are preparing a lawsuit against these insurance companies that are denying business interruption cases, which if that happens, we're encouraging all of our clients to get on that, because that's where the insurance should have kicked in, not on the work comp. And that would have helped a ton of businesses. So if that happens, great. In regards to how these claims on a work comp perspective are going to impact our clients, that's still up in the air. So we were on the phone with the WCRB last week, and us, along with a lot of other agents, were petitioning to have any COVID-related claims removed from their experience rating. And so that would take away the brunt of the impact of any COVID claims. So while your loss runs might look poor, because you might, let's say you have 100 people and one of your guys got in there and got 40 people sick, and let's say you got a relatively unhealthy workforce, like 40 people get relatively sick. I do want to ask you about like a site claim attached to this too. But if 40 people get sick, I mean, your loss runs are going to look like they'd never looked before. And if those impact your experience mod and you've been doing relatively good, like your experience mod is going to triple or quadruple. So depending on how that goes, which I think it is going to lean in the direction of it not being compensable on the worksheet, which means it won't impact our clients' mods, which would be ideal, like great news. But that's still up in the air. So we should be hearing back in the next like week or so. And then we'll send a bulletin out on what it is, because that's the main ticket. Like if work comp just has to pick it up, the insurance companies are footing the bill, great. And that's all explainable. So during the underwriting process, typically what we do is we go through every single loss that our client had and explain exactly the circumstances around those losses. It's important to tell the insurance company, here's what they've experienced, here's what they've done to demonstrably show that they are no longer going to have these type of claims. And if we can explain, like, this guy was a bad apple, we hired him, 2 days later, he left the job, and now we have a post-term on our, and it turns out to be $100,000, like, explainable. It's an anomaly as opposed to a pattern. So if it doesn't impact their mod, I see this as being negligible. If it does impact their mod, we have a whole new bag of issues we got to deal with. Yeah. So I guess some silver lining there on that. In regards to the site claims, I could imagine folks on the front lines, because we have a few hospitals that are our clients. If you're on the front lines, is like just the specter of COVID enough to like, hey, I don't want to go into work, like they're forcing me to come in. Is any of that like a potential work comp case, like from a site claim? Like I don't know if that's too loosey for you to answer, but like
it's a complex one. We at the office, we actually had a scenario posed to us where there was a manager of a nursing home and a series of patients, passed from COVID, because this, of course, affects the elderly to a significant degree. And the question was whether or not she had a compensable site claim just from losing and being surrounded by so much loss.
Sure.
The answer is I would have to say maybe.
Yeah.
I would say this is not open and shut because, for example, if she was literally jumping in and being forced to intubate somebody with a respirator, or was providing emergency medical treatment that she shouldn't have because of her position, that could certainly be seen as traumatic, and that might be the cause. On the flip side, she is not being subjected to anything beyond what is normally in the course of her work, where if you're dealing with the elderly, people are going to pass. Sure. So that would be something that I would argue before a judge, and we would see. There's definitely going to be a lot of interesting arguments. The one that I feel more strongly about would be someone who is claiming a psychiatric injury merely stemming from the fear of contracting the disease. And if somebody happens to be, be a hypochondriac or have a particular, aversion to germs, I don't believe that would be a compensable injury because there's no actual threat to this individual that is greater than the general public, since everybody is very likely going to contract this at some point.
That's a crazy thought.
Now, perhaps is there an argument for a doctor or nurse, somebody
That's
who's
where
literally
I'm more
frontline?
Frontline folks coming into work, like, hey, we weren't provided, like, because that was part of the problem. Maybe not here in California, like the hospitals have like 25% capacity, but somewhere in like New York, where they were flooded with folks, they said they didn't have the appropriate PPE, they didn't want to come into work. Like, I feel like that is kind of reasonable.
Yeah, there's definitely a whole line of cases of people that for example, were, let's say there's a hospital worker who has a patient's blood splash on them, and the person was afraid of contracting HIV.
Sure.
I would actually have to look at what the outcome of that case was.
Yeah.
So there's definitely precedent dealing with all these things. But you can definitely be sure that claims will be filed. I can guarantee.
I don't know. Like, over the next 3 years, this is like, someone should do a case study on this and just figuring out, hey, what's the actual impact of these workers' compensation cases, like from top to bottom on COVID? That'd be very, very interesting. I don't want to do it. That sounds complicated, but like, it would be very interesting to see, because I do think there's a sense of a new normal, because we've seen these before. Like, this isn't the first coronavirus we've had. We've had 4 in the past 20 years, which means it's going to happen again. I haven't figured out. We need better systems in place and a better plan, because this will not work.
Yeah.
Doing this.
Actually, I have another one for you.
Okay, let's do it.
What happens if your employee is working at home and he trips and falls over his own power cord? Is that a compensable injury?
California, yeah, for sure. I mean, realistically, that's the crappy part about this whole is like, you now have a massive amount of the workforce that didn't think they'd be working from home. Has to. I mean, is there case precedent for that?
No, it would be exactly right. It would be compensable because the individual is working at home. Although the one caveat I would have is that it needs to be at the direction, either explicit or implicit, of the employer. So if you have an employee who's working 9 to 5 at the employer's place of business, and then on his own, whether the employer's aware of it or not, unless they told him that he has to. But if he goes home and at 10 o'clock opens up the laptop and works for half an hour and then trips over a power cord, I would argue that that's not.
Sure.
But anybody, yes, who's typically working at a job site and now working from home remotely, a majority of those injuries would now be classified as, arising out of and in the course of employment.
Well, that's a whole nother problem. Like, there's going to be claims from that too, especially because it's not monitored. Why wouldn't you? If you knew you were somewhere on the chopping block, like, tripped at home. Yeah, that's whack.
I don't know if employers want to start installing, little Arlo cameras in all of their employees.
Hey, we have to
right over the workplace.
Yeah. That's there's just going to be ripple effects of this. Yeah. We're going to see how it pans out.
Here's one last one, and this is genuinely one of those questions presented by N6220 that we don't have an answer to. But when there's a very quickly pushed out emergency order, there's going to be questions that need to be answered, and this is one of them. The wording is that the person has to be working at the workplace, and it says it has to be at the direction of the employer. Now, that word direction has not actually been clearly defined. So there's a scenario where for 95, 99% of people, office is closed, we don't know when we're going to open, please work from home. That is clearly the direction of the employer, you need to work at home. What about a scenario where the employee is given the option? The employer said, either you can work here at the workplace or you can work at home. If the person has an option of working either in the workplace and is working at home, and they contract COVID-19 at the workplace, I would potentially argue that they wouldn't be entitled to the presumption because it wasn't the employer who actually created the need for their increased risk and exposure. Rather, had they chosen,
that's a good strategy.
they could have been at home. and it was their choice to go to the workplace. So the only reason potentially that the governor, and we can't get into his mind unless he starts tweeting.
Sure.
But if the theory behind this was we're trying to take away some of that risk of being forced to expose yourself at a greater degree, then potentially if you had the option, it wouldn't be subject to this presumption.
So that's a good strategy then, right? So give your folks the option if you can tolerate, having a mixed workforce, which would be more difficult, to do that until June. Or June 9th, what is that, June 19th?
July 5th.
July 5th.
Yeah,
Jeez.
July 5th. And after that, it's anybody's game.
Bring him back.
We'll,
if it doesn't get extended.
We'll see what Sacramento wants to do.
For sure.
Or if the governor extends it, we just...
So the direction thing, I'm a little curious. So the direction has not been outlined, but something like AB5, that's in there, right? And direction of the employer. Like, is someone, so in regards to subcontractors? Isn't that one of the tests that's in there? Are these subcontractors under the clear direction of a separate employer? I feel like that might be.
I mean, yeah, essentially now what we're doing is we're just adding.
Layering.
We're just adding two problems on top of each other. So the independent contractor versus an employee argument is already fraught. So now the employer is forced within 30 days to also decide if potentially they have an independent contractor defense.
Oh, no.
But another caveat to this is actually maybe not, because this doesn't state, for example, if let's say the post-termination defense would still apply. So if you fire an employee, but he was actually working at your workplace within 14 days, you would have a defense to the claim, but I don't know if you have a defense to COVID. That's something that I'll definitely be arguing, but these are,
It is going to be that. I feel like someone's going to stand in front of a judge and the judge will be like, I don't know what to do. And the defense like, I don't know what to do. Like, because it's just, it's not clear.
Well, luckily, at least with COVID-19, unlike your traditional post-termination cumulative trauma, at least we can prove or disprove the person has COVID-19.
That's legitimate.
So, we have that small silver lining.
Yeah.
But as far as what all this means as everybody's trying to go back to work, a lot is up in the air, which I guess just means you're going to have to listen to a lot more of me.
Yeah, 100%. That's a good quality right there. We'll bring you back. So if you're going to leave our listeners, which are predominantly just employers, HR directors, just with a few tips on what to do when coming back to the workplace, what would those be?
Number one, quite simply, like you already stated, safety first. Institute all the safe at-work procedures that you can. It sounds like a no-brainer, and that's why it's number one. Number two is immediate communication. Communicate with your broker and insurance company, expedite it as necessary. But keep in mind that even if, as a defense attorney, I want to set a deposition of the applicant, within that 30-day window, I need to provide at least 15 days, unless I can send a process server and track him down, in which case it's down to 10. But I need to actually find him.
Sure.
So we have to assume it's 15 days minimum. It's going to be 20 days if we're taking a standard deposition where we're also demanding production of records. So with those type of time constraints, every day matters.
Sure.
Potentially do testing. Some of those workplace procedures to ensure safety could be requiring your employees to perhaps certify that no one in their household has contracted COVID-19. And if they have, that they will at minimum themselves put on all the protective gear, or perhaps that means they don't come to work.
Self-isolate.
Definitely if you know that your employee has been traveling or hasn't been practicing social distancing, let your insurance company know. These are all valid factual bases to potentially rebut the presumption. If the applicant was...
So if let's just say, Bobby's in my shop and they're, I don't know, manufacturing some widget, right? And I know Bobby just went to, probably not Italy, somewhere on the East Coast for a week to see his family.
Yeah.
What kind of documentation, if any, should be done on something like that?
I mean, you could definitely, ask Bobby on a weekly basis, have you traveled?
Yeah.
Have you been anywhere? Have you left your home? Have you been anywhere besides to and from your own house, to and from the grocery store, to and from the workplace? Have you been wearing a mask when you leave the house?
This is a good idea. We could put together a checklist for our clients.
Yeah.
Okay.
This type of investigation, I mean, it can be done by the employer. Ultimately, it's the insurance company that needs to make the decision. So one of the tools that they have is they can set up an examination under oath, essentially asking the applicant questions while it's being recorded with the applicant's express consent. So this would be a scenario where they're going through and asking all those questions. But on the front end, any information that you as the employer have, definitely extend it. With that referral, the second that claim comes in the door, tell your insurance company about your sick pay policy, about your PPO policy. That's another big one that we already talked about.
Sure. Okay. Well, cool. I think that's the next move is let's get a battery of questions together we can send out to our clients.
Yeah.
Sweet. I think that's it, man. Unless I missed something, I think that's a very, very thorough overview of how this is going to impact our clients and work comp and the way it's going to respond as far as we know so far.
Yeah, no, John, it's not you. It's Gavin that's missed some things.
Exactly. Thank you. Well, thank you for coming in, man. I really appreciate it. Really appreciate the time. I hope you and your family stay safe and don't get you crazy during all these times.
Yeah, and I'll be back shortly.
Let's do it, man. All right. Thanks for listening, guys. Talk to you later.